The fascinating discussion during the first panel about the immigration developments in Utah and Indiana, which I did not know. I did know something about Florida. And it's great to be here to talk about this today. It's also great to be indoors, isn't it? This is another one of those weeks that thankful I passed up a career in roofing here in Washington. We're going to talk about the sort of legal constitutional question. That is, sort of how much room do states have to regulate and legislate in the area of immigration. It seems to be the one thing everybody agrees on is that the federal government has the ultimate authority to set the laws on immigration. No state can have its own immigration policy. No state can say, you know, we're willing to accept people from Canada and France, but not from Russia and India. That everybody knows that ultimately the federal government sets the immigration law, immigration policy. The Constitution says that Congress can establish a uniform set of laws of naturalization, that federal law is supreme, and that in the past, the Supreme Court has sounded that theme on a number of occasions. There's a famous case 70 years ago, 1941, the court struck down, Pennsylvania had an alien registration law. The Supreme Court struck it down, and Hugo Black wrote one of these really strong, short but strong opinions that basically says immigration is about foreign relations and that it's the exclusive power of the federal government and that no state may add or take away from the effect of any federal law. And if you read that, you still see that opinion quoted, you'd really get the sense that states have no role at all in this area. But in the 70s and years afterwards, the Supreme Court would say the states have the historic police powers, that the states are the ones that have the authority to regulate for people in their own borders, health, safety, welfare. And so the truth is there's a lot of gray area here, that there are past precedents, the Supreme Court that says immigration is exclusively federal, but there's a lot of practical reality that says that states have a lot of authority to regulate immigrants, residents, people who are living within their own borders. I've been doing this, writing about the Supreme Court for 25 years, and for almost all that time, the only immigration cases I remember writing about were interpretations of federal immigration law. Now in the last couple of years, we've got something new, which is Arizona sort of leading the way of saying the federal government hasn't done the job on immigration, so we in the states are going to move on our own, take our own set of laws to regulate illegal immigrants, to deal with illegal immigrants. So the legal question is, can the states do that? How far can the states go? So that's what we're going to talk about. We're very fortunate here to have a panel of three good people to talk about it. Greg Zeller is the Attorney General from Indiana. Peter Spiro is a law professor at Temple, somebody I and other reporters have called upon to offer sort of smart commentary on immigration matters. And Carter Phillips, who's one of the, I think, best known and most respected advocates in the Supreme Court. And it just so happens that Carter was the attorney this year in the first real big case on this issue called Chamber of Commerce versus Whiting. It was addressed earlier. And so Carter's going to talk a little bit about what was the issue, what did they decide, what's it mean, and then I'd like to hear some other views on what the take of Whiting.
Yeah, Chamber of Commerce versus Whiting is interesting in a number of respects. The first one is that while the name of the case is the Chamber of Commerce, the reality is that the petitioners were civil rights groups, labor groups, and the Chamber of Commerce, which are an odd coalition, candidly, who had come together to effectively challenge what Arizona had done in 2007, stepping into the vacuum that the previous panel has been talking about, where the sense of the border states, obviously, that the federal government was not enforcing the law as aggressively or certainly to their liking or maybe not as aggressively at all. And therefore, in that context, what Arizona did in 2007 was enact statutes imposing certain types of penalties and obligations on employers. So unlike the more recent Arizona statute that's the subject of ongoing litigation right now. We can talk about that as well. This was focused exclusively on the employers, and there were two elements of it that were of particular concern to the challengers. One was the requirement that that all employers have to use E-Verify. Congress, in adopting E-Verify and in extending E-Verify over an extended period of time, had consistently left it as a voluntary program to be determined at the discretion of the individual employer whether or not to participate, and for good reasons. There are a lot of errors in the program, so you get a lot of false positives and some false negatives. Over and above that, there are limited resources, and the question of whether or not you could have the entirety of the United States suddenly adopt and try to employ this computer system is at least subject to serious question. And so that was so, but Arizona nevertheless said, Congress may have said that E-Verify is voluntary at the federal level, but it didn't really speak to what's permissible at the state level, and so Arizona purported to fill that particular void. And then second, even though Congress had in a statute enacted back in the 1970s and in response to an earlier decision of the Supreme Court saying that the employment relationships involving potentially unauthorized individuals are matters that the states can regulate, Congress then enacted a specific statute that said it didn't want the states to impose any sanctions over and above the sanctions that the federal government was imposing. And then, unfortunately for me at least, there was a parenthetical in that provision that said, except by licensing or similar laws. And so the question was, even though Arizona could not impose even a $1 fine, either civilly or criminally, for an employer hiring an illegal alien, the question was, could they nevertheless adopt a statute that effectively stripped the corporation of its ability to do any business in Arizona? And what the Attorney General at the time, or the Governor at the time, Napolitano, said was the death penalty for corporations doing business within the state. So you have this sort of odd situation of a punishment that looks wildly disproportionate to what we know Congress did not intend to allow, a $1 fine. On the other hand, doing it through something that could be viewed as a licensing law or something similar to that. And the question then is that permissible under the Supremacy Clause, under the preemption doctrine that's going to be the focus of most of our conversation. And ultimately, the Ninth Circuit upheld the Arizona statute, and the U.S. Supreme Court affirmed on a 5-3 vote, with Justice Kagan not participating because she had been in the Solicitor General's office at the time the case was originally presented to the court, and the court asked for the views of the Solicitor General as to whether or not to hear the case. And on the two issues, what the court held is, I'll do them in the opposite order I presented them. On the express preemption provision, the Chief Justice said, look, the statute says licensing or similar laws. This isn't quite a licensing law as we understand it, but given the notion that Congress clearly wanted to leave some room for the states to operate in, we conclude that that's a perfectly sensible way of going about it. And particularly so when it is required under state law, and presumably would have been required under federal law, that the state can only follow the, quote, determination, and that comes out of the Verify portion of this, the determination of the federal government. Now, you know, the big issue then is, you know, does the federal government in fact make a determination of someone's status, and in what context and in what form, and how does that get communicated, and how effectively is that communicated? But the court was very clear in saying, you know, as long as what we're talking about is the state following the determination of the federal government with respect to the status, then one, if they determine that there's been a violation, that there's a federal determination, then the state can impose the sanction of the death penalty. And then with respect to the E-Verify system, again, Congress may have said it's not mandatory at the federal level, but it can be mandated by each of the individual states. And in that, they took some comfort from the federal government's own brief in the case, in which they said that it wouldn't be the end of the world for the states to come in and mandate E-Verify, that the federal government would be able to deal with that. They will be able to test that theory very rapidly, I suspect, as virtually every state that has any interest in this will almost certainly adopt the mandatory E-Verify step. It's essentially a politically costless exercise. And we'll see whether or not the federal government, in fact, can deal with that many employers simultaneously tapping into their system, and what will happen as a consequence of that. Anyway, that's the decision. If you ask me to just sort of write on a large canvas at the moment, what I take away from it in terms of the ongoing debate, seems to me that at a minimum you'd have to say that whatever was sort of the core feeling that you would take from Hines versus Davidowitz 70 years ago, that immigration is largely a matter for the federal government, and even after DeCanis, where the court said, no, the employment relationships remain a matter of state concern, Congress coming in afterwards and seemingly pushing itself and the federal government much more into the mainstream and as the primary enforcer at this point, the court clearly reacted to the failure of the federal government to do more and has now found a role for the states, and it's clear to me at this stage that the states will fill that void going forward, because the door has been left not only slightly ajar, but actually rather substantially ajar, at least in my judgment.
Peter, what's your view about what to take from the Supreme Court's handling of the Whiting case?
I agree with Carter's assessment. The opinion itself is quite narrowly drawn. So the court was careful not to have any loose language in its opinion, tipping its hand in any sort of obvious way, one way or another, with respect to other measures on the table, such as SB 1070. So you could frame it as a narrow decision that really just interprets the E-Verify question and then the savings clause in the 1986 Immigration Reform Control Act. But I think, in fact, the court is sort of tipping its hand here towards some level of tolerance for state activity. And I think it was useful for David to set up the panel with this 1941 decision. In fact, you can go back to 1876 with the Chai Lung decision of a much more hair-trigger standard under which the states are completely ousted from this area. And I think it's that Whiting is laying the groundwork away from that sort of hair-trigger standard, in addition to being a very important decision in its own right. So you've got, obviously, on E-Verify, and then with respect to the interpretation of the license savings clause, there's a lot that states can do with that ruling, obviously. And so the immediate implications for ordinances such as the Hazleton ordinance, which the court took and remanded back to the Third Circuit, I think that really the court was giving a green light to ordinances such as that. So a narrowly crafted decision probably with broader implications than one would take away from the reasoning itself.
Well, Greg, what use have you put to it in Indiana?
Well, the Whiting case actually came at a very timely period. It was during the legislative arguments over our own bill, 590, which was first modeled after the Arizona statute. But what was interesting was that there were questions about the constitutionality of our own 590, and I think it was probably headed to summer study until the Whiting case came out and showed an opportunity for the state to play a role, which breathed new life into the areas dealing with E-Verify particularly. So our legislature used that as the model. So we had the benefit of a Supreme Court decision, and it gave the opportunity for my office to step in and play some role in explaining how the state may have this role that could be defended on challenge. So at least in terms of the E-Verify provisions, we have it where it only approaches those who are employers, state government, and those people who contract or subcontract in state employment. So that's pretty safe. We also set it up so that it's only the loss of tax benefits. So I think that's probably the strongest way to defend, again, with some benefit of hindsight looking at that case. So it was very timely for those people who would have rather not had an immigration bill at all. It was untimely because I think we may have just been watching from the sidelines. So again, depending on which side of that argument you were on, you were either glad of the timing or not so glad.
Gordon? The interesting thing about the court's intervention in this case was, at least from my perspective, that they did. And because, you know, normally the U.S. Supreme Court lives for conflicts in the circuits, and that's what they wait until something develops. And in this particular case, there was no conflict in the circuits. Arizona had its statute. There was an Oklahoma case that's out there that's got a somewhat different spin on it. Obviously, the Hazleton case was pending, but that had been pending, it seems like, about for 10 years. So you know, you could not realistically say to the court there was going to be a conflict in the circuits at any time, at least in my professional life, as I sat there. On the other hand, it was absolutely clear that the amount of state and local legislative activity and the churning that was going on was pretty remarkable. I mean, there were hundreds of bills being considered and enacted during that period of time. And as a consequence of that, I mean, our strategy, and it was on behalf of the Chamber and the civil rights and the labor groups jointly, was to say, look, the legislatures throughout the United States should not devote the resources they're going to have to fight over this fight. Litigants shouldn't have to go chasing into court over every one of these provisions without anyone knowing what the basic guidelines are. Now, I can't say that what I got by way of a final answer was what I was hoping for. I'll readily concede that. On the other hand, at least some level of certainty coming out of the Supreme Court does have the benefit of certainly giving guidance to the states as to how to proceed, and there'll still be issues to litigate, to be sure, but at least there are certain sort of safe harbor principles you can deal with. And it has, as the previous panel suggested, you know, the real possibility that if enough states tinker with this scheme in enough different ways, at some point it will simply be impossible for Congress to ignore for any period of time, and they will step in and fill up that particular problem. So, you know, I'll take credit in some sense for moving the public policy debate along in a positive way, even as I go off and slink in a corner and take my defeat.
I was about to give you credit for that. He filed a very effective cert petition saying to the Supreme Court, hey, there's legislative activity all around the country on this immigration question. You ought to weigh in and take this case and weigh in on the employment, which is what they did, and they came out the wrong way from your point of view. But so now that seems to be fairly well settled, to the extent these things are ever settled. That is, that the states can take action against employers who hire illegal immigrants. And Arizona said, we can impose the death penalty. We can put them out of business. But that's only the one issue. That is, can you take action against employers? The big disputed issue, I take it, that's got everyone's attention in the last year is, can you put your local and state police into the business of sort of arresting illegal immigrants, sort of enforcing immigration law? And that is still, right? That's still what's out there. That's the SB 1070 case. Can any one of you sort of tell us where we are on that issue? SB 1070 was challenged by the Obama administration and as well as civil rights groups, and is now sort of pending.
Since you asked me to do that ahead of time, I suppose it'd be hard for me to...
You better be able to say something.
Exactly. Otherwise, we're going to have a big lull here for a while. You know, the SB 1070 involves essentially 4 provisions. The Ninth Circuit has struck down all 4 of the provisions, 2 of them by unanimous vote, 2 of them by a 2-to-1 vote, and the state of Arizona has retained Paul Clement to seek certiorari. Whether he'll do that with respect to all, he's the former Solicitor General, whether he'll do that with respect to all 4 of the issues or only the 2 in which there was a dissenting vote will be interesting. As David said, all 4 provisions carry with them the same notion, which is that they're going to regulate employees and the individuals rather than regulate what the employers do. The first provision has to do with whether or not you have to, again, make a determination of the individual's status, and that determination is, again, supposedly based on whatever the federal government says. So that feels a bit like a deja vu situation, at least from where I'm sitting, that the Supreme Court's already said what they think that states can follow the federal's determination and then kind of go with that. So unless the court's prepared to say you can't regulate on the individual side and can only regulate on the employer side, which seems somewhat counterintuitive to me, that one at least has some serious issues. That issue also, the way the Ninth Circuit approached it, which is to me particularly interesting, is they gave a tremendous amount of weight to the fact that foreign governments were complaining bitterly about this and saying that it was preempted in part because this was interfering with U.S. foreign relations. The dissent that uses the fairly colorful claim that this is a heckler's veto that gives foreign governments the opportunity to complain bitterly about something and thereby rendering it unconstitutional under our system. That's going to raise that huge debate about foreign influences of our U.S. constitutional law, and that'll be
raising a red flag in front of Justice Scalia.
Yes, at least Justice Scalia, if not others. And then the second provision is it makes it a state crime to violate the federal laws with respect to alien registration. That one, all three of them concluded was unconstitutional, in part based on Hines versus Davidowitz, frankly, that the registration is something that really is uniquely in the federal government's control, and therefore that's one that all three of the judges on the Ninth Circuit thought was all right. Then there's the specific punishments that can be imposed on employees, and there again, all three of the judges agreed that that kind of a punishment was something that Congress did not intend, that it went to great lengths to try to impose punishments on the employers, and therefore the states are free to supplement, but the idea of punishing the employees, that Congress really had not intended to allow that. And then finally, there's the process of arresting for violating the federal civil laws and the extent to which the states have inherent powers to enforce civil laws, and to do that through their criminal statutes. And that one's particularly interesting, if only because the dissent says that the majority's opinion on that issue is completely made up. No one had heretofore argued that the states lacked the authority to enforce, that in fact the federal government in its challenge had merely questioned whether or not it was reasonable to expect that that kind of state enforcement wouldn't be so cumbersome as to interfere with the overall objectives of Congress. So, I mean, if I were going to guess, I would guess that Arizona would likely be on its strongest grounds, obviously running with the dissenting opinion and saying those two provisions ought to be unconstitutional. It'll be interesting to see whether they decide to raise the other two issues as well.
I read a lot of Ninth Circuit opinions that come up to the Supreme Court, and for the most part, I think they're sort of a trailing indicator or whatever. If the Ninth Circuit sees it one way, the likelihood is the Supreme Court's going to see it differently.
That didn't work in Whiting, by the way.
That's right. That was the rare case where the Ninth Circuit was affirmed on a matter of a controversial issue of some substance. Well, Peter, you're of the view that the court is sort of edging in the direction of saying more room for states. So how do you see the Supreme Court handling the 1070 issue if this cert petition comes up this summer?
First of all, I don't think the court's going to be in any rush to take the case. I agree with Carter. It's sort of a mystery why it took the Whiting case, given that the Ninth Circuit had upheld the state law. It had been more than 30 years since the Supreme Court had said anything about a state role in the regulation of immigration. So this seemed like maybe an appropriate time for it to intervene in a case that was a little less of a hot potato than something like the SB 1070 law. And so I suspect that the court will duck on this round, having just done something in Whiting, given some guidance, some sort of cue on the general questions.
They're not shy on controversial. You think they'll pass on this because it's a preliminary?
Right. Well, they'll know they'll get another shot at it. I mean, either at Arizona or, of course, you've got other similar laws working their way up the pipeline from other states. So Alabama's got a law that in some ways is more extreme than SB 1070. You've got Georgia, South Carolina. You've got a case out of Indiana. the Supreme Court likes, of course, percolation. It likes to get some diversity, it likes to get views from the lower courts before it weighs in on an issue here, and that's not always true, obviously. Sometimes the court is sort of champing at the bit to get at important issues, but here's one where I think, I'm not sure the court's got that much of an axe to grind on immigration as an issue. And so I think the longer that it can sort of comfortably stay away from the questions presented by SB 1070, I think it will. So I wouldn't be surprised if it denied if it refused cert on this go-round. I think sooner or later it's going to have to get to these issues, especially given that Whiting was narrowly framed. And when it does, I'm with Carter. I think it'll probably split the baby, and some provisions are likely to stand up. The policing ones are the more likely, I think, to stand up. The provisions that I think are more problematic are those that make immigration, undocumented immigration status, a crime under state law. I think those provisions the court is going to see as having gone too far. So even though the court is creating more space for state regulation of immigration, it's going to be setting limits. It's not going to be a blank check here.
Now, Greg, you have essentially the same issue in Indiana, right? Well, where does that stand in the federal courts there?
Well, in Indiana, they did have two enforcement provisions. Both have been stayed under a TRO. I announced this morning that we would not seek appeal of the restraining order, that we would continue to defend in the federal court in Indianapolis. But I think on this point of where we go, I think you'll see a lot of states willing to file amicus briefs supporting cert, because I think the tendency in the history of the court is probably all accurate. But again, the states are the ones, I think, that are leading the pressure. Indiana being a great example, where we saw in the Supreme Court opinion a roadmap on how to proceed. Similarly, the problems we have on the enforcement side, which again I had hoped would go to summer study, waiting for another Supreme Court opinion to give us a little more guidance. But if you're looking to have a reasonable state approach, we're going to need some reasonable roadmap that's lacking coming out of Washington. So the Supreme Court, being the only entity in Washington willing to step into the role, I think would be well supported by the states to engage in a little more guidance.
Carter?
Yeah, I mean, I guess I disagree with Peter in part because the court took Whiting knowing SB, the Arizona statute was out there.
Right.
I mean, when we filed our cert petition, the court asked for the views of the Solicitor General, which is this arcane mechanism by which they basically don't decide whether they think the case is worth hearing, but ask the federal government what its views are. And candidly, we had asked the court to do that because I didn't think we had a basis on which to get the court independently to say this was an important issue. And that, as often happens with those requests, sat there for a very long time because it's the only pleading in Supreme Court practice where there is no deadline for filing, and as a consequence, it always ends up at the bottom of the stack of the lawyer's office. And we'd had our meetings with then General Kagan, now Justice Kagan, and the staff, and it was pretty clear that there were two different minds going on within the federal government as to how best to deal with this. And then the new Arizona statute gets enacted, and two things happen. One, people like David Savage and all of his colleagues call up and start saying, well, what's the relevance of your case to this firestorm of concern that's arisen as a consequence of that? And so a case that was really kind of a backwater and kind of lost in the shuffle of Supreme Court advocacy suddenly takes on much greater prominence than it ever had before.
We will shamelessly hype anything.
And we appreciate that, by the way, those of us who are seeking Supreme Court review at least. And then we also got word back from the Justice Department that they were now somewhat more interested in Whiting as a consequence of the actions they were taking vis-a-vis Arizona and the other litigation. So, clearly, when the court stepped into this at the suggestion of the federal government, and indeed took not only the sanction provision, but also took the E-Verify, where the federal government had said, don't take the E-Verify issue. It seems to me they knew what they were sort of walking into to some extent. And my guess is, having written as carefully as the Chief Justice did that opinion, without previewing where they're going to come out, I think they're going to be more in the nature of anxious to take on the next one. And Greg's absolutely right. If some substantial number of states are there screaming, we got to have an answer to this question, I think it's going to be really hard for the court not to take the case. Now, again, one, I don't know that Arizona's going to ask for a review of all 4 of the questions. I don't know whether the states would ask for support on all 4 of the questions, and I don't know whether the court necessarily would be inclined to grant all 4 of the questions. They might try to figure out some way to, even at the cert stage, kind of split the baby.
Right.
Well, I was going to add, Carter brought up that Paul Clement is handling that case, and the former solicitor is a great friend of a lot of states as he's handling the challenge to the Health Care Act. So this idea of where federalism stands, he's a very good advocate for the state's positions, and I think he recognizes that in bringing his case, he will have a lot of state support on just the point I was trying to make. He can count on a number of states leading amicus to support having the Supreme Court weigh in, again, recognizing the federal failure, because you don't want states having to try to make it up themselves. We've seen some of the problems with that. In Indiana, we had hoped to have guidance somewhere. So I think you'll see a very strong voice on the part of a number of states seeking this type of guidance out of the only body in Washington that seems still functioning.
Yeah, I would make it 3-1. I think, if I'm reading this correctly, I think the likelihood is the Supreme Court will jump at that case and take it, because they see there's this big conflict. A lot of states are interested in it. The law is quite unclear whether the states can use their own police to, in effect, help out the federal government enforcing the immigration law. And so I think they're sort of inclined to take it. And I sort of agree with Carter, is that John Roberts wrote this opinion to answer the question before them and not tip off the next question, because they knew the next question was coming pretty soon. Do you see then, assume the 3 of us are right and that pretty soon they take this case, do you see it as a sort of straight liberal-conservative divide, where the conservative members are on the court of saying, yes, go ahead, states, you can push ahead on immigration enforcement, and the liberal justices sort of taking the liberal view, which is this is the federal government's bailiwick, you, the states, shouldn't be tramping on that turf? Do you think it breaks down that way?
Well, I think it's really important. This follows on Greg's point as to how members of the court sort of frame the issue, how whether they perceive this as really just a federalism issue, or whether they still put these cases into a box, a sort of exceptional category of immigration and especially of foreign relations. So even Justice Scalia, when it comes to foreign relations, is all for federal power. But to the extent that they see it as a part of other agendas, so Whiting, I think you can look at as a preemption case. And there's a preemption agenda on the court away from a hair trigger preemption standard. And so whether immigration is something that the court continues to see as different, as exceptional from other areas of regulation is going to be key, I think, to handicapping the question once the court gets to it. I mean, I agree with all of you that the court is going to have to address these other questions at some point. I'm just not sure that the Arizona case is going to be the vehicle for it.
The one aspect of it was in Whiting, and it'll clearly be embedded in the second Arizona case if it ends up there, is obviously there's a huge civil rights component to all of this, and you know, one of the I suppose gut-wrenching portions of the Chief Justice's opinion, and sort of casting aside the civil rights issues and the concerns of that entire body of the petitioners in our case, was, you know, all the employers have to do is comply with the law, and that's, to be sure, that's easily said, but you know, the reality is, and it's just going to be just as true in the new legislation as it was in the old legislation, is it's not the notion of, quote, complying with the law. It's the notion of what do you need to do to ensure that a sheriff in a local community is not going to show up at your doorstep because you've made a questionable decision, or somebody down the line has made a questionable decision. And you know, it's one of those wonderful things. You can write it up and say, well, you have to follow the federal determination, and all you have to do is comply with federal law, and all of that's pretty easy. And I don't want to be carping too much about losing this case, but I am. But the reality is that once you release the state enforcement officials, and particularly local enforcement officials, to go after, and out of Whiting, the employers, there are huge civil rights risks to it. And then it seems to me you magnify those pretty significantly when you then take it and release that same enforcement effort on the employees themselves. I mean, let's remember what the name of SB 1070 is: attrition through enforcement, which is a fairly chilling. I don't know who picked that name. I wouldn't have been at the top, at least as a PR matter. I guess I wouldn't have gone to that. But again, the civil rights part of this, of course, that will feed to some extent to the ideological divide, where at least in terms of where I suspect the four, quote, liberals on the court will react to this, is they will see this as more of a civil rights problem that needs to be resolved. How the other five will break out will be more interesting, because I do think there are portions of the SB 1070 that really do go to core federal powers, and therefore you would expect at some point for them to say, look, we're not just here for states' rights for the sake of states' rights. We're trying to figure out what the right answer is, and if we don't know what the right answer is, then we'll resolve it in favor of states' rights. But I think in a couple of these provisions, it's reasonably clear.
I'll chime in. I'd be careful writing this up as, you know, a conservative and liberal approach, because I didn't want anybody to write me up as a liberal. But I work every day with our enforcement under our criminal justice system, and I'm not hearing from my law enforcement partners, my clients, that they are chomping at the bit to enforce. That's one of the reasons that I had hoped we would have summer study on this subject. We did pass some provisions that have been stayed, but it's not a conservative approach to go against the wishes of law enforcement. So if the states were all begging for this enforcement authority in the enforcement area, in law enforcement, as opposed to just in the legislative branch, I would say that it may be more along the lines you're talking about. But frankly, I think the conservative view in supporting the interests of law enforcement is not to put them in the front line of immigration policy.
You know, normally you would expect the administration's voice to be very strong in an area like this. In other words, the Obama administration saying, we don't think states should do this, immigration is our area. But my impression is that the Obama administration's view will not be dominant. It was not dominant in your case, and I don't think the Chief Justice Roberts and the court's conservative bloc will be all that swayed by the fact that the Obama administration is on the other side. Do you disagree with that?
Well, they are the plaintiff in the Arizona case, which I think is a little unusual for the U.S. to come in to challenge these laws on a preemption ground. So that was, I think, a pretty bold step, at least as a matter of legal strategy. Yeah. But I wouldn't expect the court necessarily to have any meaning for members of the court.
See, I think the more interesting question would have been, what would the administration have done to the request for the views if Arizona had not intervened with a new statute, because I was not optimistic based on my conversation, even though there's clear sympathy, but again, the federal government was badly divided in its approach, with Homeland Security clearly being of one mind and the civil rights enforcement groups of a fundamentally different approach. And usually when you have that kind of gridlock, the answer is just to do nothing, sort of put your head down and say, oh, it's an important issue, it's going to resolve, it's going to require the court's attention at some point, but this is not the day, and then hope it comes, it doesn't happen on your watch, et cetera. And maybe I'm wrong. Maybe they would have stepped in and still taken essentially the same position, but it did seem to me there was this enormous uplift that came right after SB 1070 was enacted, and then, as you say, the federal government affirmatively went after that statute, that they had no choice but to then kind of take the position, at least as to some portions of the statute, of the earlier statute, warranting the court's review.
I had a very cynical and totally different view as to what was the delay on this case. The Supreme Court asked the Solicitor General in like November or December to weigh in on this Arizona immigration case. The Solicitor General was Elena Kagan. John Stevens retired, which we all thought he would. Elena Kagan was likely to be the Supreme Court nominee.
Well, you are,
so they waited and waited and waited and waited and waited until Elena Kagan was nominated. Then 2 weeks later, the Solicitor General weighs in. I just think she wasn't too anxious to get out front in the middle of that hot button. You don't want to have to answer more questions at your confirmation hearings about stuff like that. May I ask about something that came up earlier, which I was fascinated by the discussion about Utah and guest worker program. It seems to me it's a interesting, great idea. It'd be interesting to see how it works. But I'm interested what you guys think as a legal matter. What do you do about a state that goes ahead and does something that's, I don't know whether that's exactly the right phrase, but is some way of saying, these are illegal immigrants, and we the state, wouldn't that be subject to somebody saying, hey, the federal government controls immigration. Utah, you may think this is a great idea, but you can't do it.
Well, my understanding is that the guest worker component of the Utah law doesn't come into effect until there's a federal waiver of some description. So it's not.
So the federal government would have to.
It would have to. I mean, we have the Attorney General here, but so it's not in effect until the federal government okays it, basically.
I see.
But
That's not exactly true. There's a trigger, which is so it does go into effect at a certain date. It asks for a waiver, and so they're going to try to get a waiver, but there's still a trigger date in the law.
it will just go into effect. Interesting. I mean, one thing it seems so really ingrained in our sort of constitutional culture that the federal government has this exclusive authority over immigration. It actually doesn't have to be that way. And there are other countries in which, there are other federal systems in which provincial and state governments have much more of a say, including even with respect to the admission of immigrants. So there's nothing sort of essentially sort of impossible about a state having its own guest worker program, and I think it's really quite intriguing, and it'll be interesting to see if the Utah Compact has legs in other states. And there seems to be some confidence in this room that if you get enough states doing different things, the federal government will necessarily get its act together for comprehensive immigration reform. I mean, I wouldn't be quite so confident that that's going to happen. And again, the riff here is, well, patchwork is bad. So you can't have a patchwork of immigration laws. But that's what federalism is about. I mean, federalism is about having different laws in different jurisdictions. And at some point, you're going to, when you have direct conflicts between different states and the states and federal government, you're going to have problems. And obviously, having to comply with lots of different state laws is a problem for business because it's just it's more work for the lawyers to figure out how to comply with them. But there's nothing sort of essentially wrong with having different approaches on these different issues in different jurisdictions.
And speaking of sort of different approaches in the laboratories, I had occasion to write a couple weeks ago about something that I maybe should have been more aware of, was that California, and I think it's now up to 13 states, I think Utah was one of them, offered in-state tuition to students who were illegal immigrants in the state who had gone to high school and graduated from high school. There was a provision in the, I think, 1986 Immigration Act that said no benefits on the basis of residence for any illegal immigrants. And California's law was very neat. They said, oh, it's not on the basis of residence. It's on the basis that you went to high school for 3 years there. And California Supreme Court upheld that. There was a cert petition filed in the Supreme Court, and they denied, they refused to take that up. So at the same time, there's an awful lot of publicity to the Arizona sort of tougher enforcement law, but there's another set of states, Maryland and Connecticut joined that recently, sort of going the other way of saying, these kids grew up here, there's some of them are there from they're 2 years old, they've done well in high school, why can't they go to our colleges and universities like other students? So there is a lot of ferment going on. And we have somebody who wants to ask a question here in the front row.
Just going to ask that in terms of this discussion. I'm Kate Yorkowski. I'm a congressional correspondent with the Hispanic Outlook on Higher Education. So I've been doing a lot of stories on the DREAM Act. And to me, the difference between the state DREAM Acts and the federal DREAM Act is that the states are allowing in-state tuition, but they still, at least if immigration is still a federal matter, cannot offer these students a work visa. They still, once they have their state-subsidized college degrees, they still can't work legally in the country. So are you seeing now that there may be a way for the states to say those students who've gone through the DREAM Act to actually graduate? The DREAM Act federally doesn't say you have to graduate, you only have to attend 2 years. But maybe the states will say, if you actually graduate on our dime, we'll give you some kind of a work visa? I mean, can they do that?
You guys know the answer to that question?
I mean, it has to be no, but well, I mean, look, it's this, you know, to sort of use the flip side, you can do it in the E-Verify context. Obviously, Illinois had reacted completely differently than the other states and concluded that E-Verify was a failed scheme and outlawed it. The federal government challenged that and was struck down as preempted. My sense is that if the states try without approval from the federal government to alter the status of anyone who would otherwise be subject to the federal registration scheme, I mean, if that's not a conflict or an obstacle to the achievement of Congress's objectives, I don't know what is. So I would be, you know, as my young son used to say, I would be stunned if the court would uphold that.
Be glad to take any questions on the legal or constitutional issues, and I think you would like to go and get the microphone first.
Take the sponsor's prerogative. You haven't talked about the Smith's pending bill. So Chairman Lamar Smith and the House Judiciary Committee has introduced a bill that would significantly preempt state activity on strictly on the employer sanctions side. Now, who knows if it will pass, but what does that do to these predictions that you've set up and the picture going forward?
Yeah, I mean, I think at least the version of the legislation that I was asked to comment on a couple of weeks ago clearly would overrule Whiting, at least with respect to the sanctions provision. Probably would overrule it with respect to the E-Verify, but you know, still doesn't necessarily change how the court is approaching this basic question, unless it adopts the view, which I don't think is likely, that state enforcement against the employees is completely off the table, unless you can infer that by taking the employers off the table by more substantially that creates an inference with respect to the employees. I think it's still a tough call.
So I might even encourage a loose reading of SB
It might.
I mean, it's a critical point here that Congress can always step in if state laws are really creating a serious problem, then Congress has the affirmative power to preempt. I don't think anybody denies that. So, but that goes even to the foreign relations question, where you can see the origins of this doctrine that the federal government has exclusive power over immigration in the concern that when it comes to foreign relations, you want to squash anything that interferes with foreign relations even before. You don't want to let things get out of hand, even if Congress can step in at some later point. And that, I think, was true of an old world where, Hines versus Davidowitz was decided in 1941 in the lead up to World War II. If a state did something that even in a minimal way interfered with a very sensitive balance of foreign relations at a time when sort of survival was at stake, you just couldn't tolerate that. Today, even though you've got foreign governments coming in and complaining about SB 1070, you're not talking about World War III. And so the court will be more confident that if in fact these state measures are creating problems of foreign relations, that Congress can do something about it.
I was going to throw in on the point of federalism generally, as much as I counseled our own legislature for a wait-and-see approach and looking for guidance, I never criticized what they did in Arizona. I've been complimentary of all the states in their own struggle. So if you're going to be a true federalist, you have to encourage the states to create the crisis by which Congress might finally act. They don't act without a crisis, so I would encourage as many states to act on their own and push the federal government. Clearly, I would appreciate preemption in this area because I think it is their role, but in failing to do that, we need to create the crisis, and so it's a strange thing to suggest the states are the ones who are going to have to lead to a crisis, but I think that's literally what we're...
It's largely the business community and the individuals who are between the rock and the hard place as you squeeze that. I mean, I hear you, I understand that, but boy, that's a tough price to pay for the
Well, Indiana's
people on
still
the street.
welcoming to all business, even no matter what other states do. I'd like to make that point real quick.
Good
I was
call.
thinking there's a quote for some of the journalists in the audience. We're trying to create a crisis.
Hoosier
where they-
hospitality is still our motto. So.
How about right here?
My name is Samar Chatterjee from Safe Foundation. I'm glad you picked the right time to take questions from the audience because the discussion was getting a little stale.
Yeah, we get that a lot.
Group of lawyers
Now,
up
my
here.
question is, on your heading, there was the Founding Fathers' view. Well, of course, there was a colon before that, but I don't think you addressed the Founding Fathers' view. And my understanding was that the Founding Fathers' view is what's on the Statue of Liberty, which says, give us your hungry, starving, and whatever, oppressed and fleeing tyranny and all that, and they should all come and be comfortable in America. But I guess once you hand this over to three-piece suit wearing Supreme Court lawyers who can range from one extreme, the Al-Qaeda type of lawyers or Taliban type of lawyers, all the way to the moderate lawyers, the discussion gets into these nitty-gritty who's doing what and what Supreme Court said on this case. But isn't this a fundamental question that we need to address? That I can understand states doing some of this because, let's say, if a person is illegal in this country, but there are 10 million of them, and they've been living in this country for a long time, so the states can consider all of them legal and provide a policy till the federal government wants to come and pick one of the guys and deport him. So why not that kind of an approach? And there should be a more fundamental way for states to be looking at it rather than be part of the federal system and competing with the federal government on immigration. You do your domestic matters, make it part of your domestic program. You deal with whoever is in this country in whatever format, and you have your own policy where they work and how they work and all that. And another point on E-Verify, my understanding is people who come in new in this country and are in the process of getting on one visa and then they're getting a green card. During that period, they're not on E-Verify, so how do you enforce that, E-Verify in that respect? Thank you.
You want to talk about the framers?
The framers, well, the framers had no, well, what did the framers think about E-Verify? There you get into sort of the crystal ball gazing of the fantasy variety. The framers didn't even, the concept of undocumented alien would have been foreign to them because, as David pointed out, the power, there's no express power over immigration in the Constitution. The closest thing is the power over naturalization. So it's not very helpful, really, to think about any of this in originalist terms, except maybe to the extent that immigration is considered part of the foreign relations power, and that really, again, was the genesis for this doctrine of exclusive federal power, is that that the nation, when it comes to foreign relations, has to speak with one voice, or so the trope goes.
Well, I'll get myself in deeper by saying that the framers might have thought that the two senators elected by their state legislature would have been out here requiring the Congress to do their job before the states were required to create a crisis.
Yeah, I suspect that if the federal government, if the founders had thought about it at all, they would have assumed that this was going to be a matter largely left to the Congress, and the Congress would, in fact, exercise its authority in a responsible fashion, and that there would be a limited, if any, role for the states, and you know that held sway for a very substantial period of time. It's only candidly within the last 25 years that you see the departure from that based on the events that we're all looking at.
Several times you brought up the point the Supreme Court has admitted that the immigration issue is tied up with foreign relations, and having worked at the State Department before, this is often considered a province of the executive rather than Congress. So are you really thinking that's the direction it's going to go in? I know other countries see it more as a regulatory issue rather than something that's legislated.
Well, the problem now is that the court sort of staked out some portion of the preemption issue. There's always there's some authority that allows the federal executive branch to preempt state law as well. So there would be at least the potential for that, although I don't know to what extent there's express rulemaking authority that would cover these particular issues. The truth is, in my own view, if it were up to me just as a political matter, I'd be much happier if Congress tried to resolve these differences and had the benefit, candidly, now of an enormous amount of state legislative activity, state and local legislative activity, to evaluate what they like, what they don't like, and then make a judgment about what makes sense for the federal government speaking with one voice. And then if they want to carve out areas for the states, that's fine too. I suspect, candidly, they did not envision that the savings of the licensing law was really intended to allow the death penalty. I don't think that if you could, put lie detector tests on the members of Congress at the time, I doubt that any of them could say, yes, that was what we had in mind. But hopefully the Congress will recognize that the court takes pretty seriously the language that Congress uses these days, rather than necessarily searching for some broader intent, and therefore try to be more precise in how it approaches the problem.
One way this may play out is if the Supreme Court takes the Arizona grants the cert petition, they would rule on it in the next term, and there's a very good likelihood, I would think, that they would lean in favor of Arizona and sort of saying we're going to allow states more leeway. Then after the 2012 election, maybe a new Congress, a new day in Washington, lo and behold, maybe the Congress may try to legislate in the area of immigration. But my impression is the court's going to move first, they will always sort of grumble about you can't rely on Congress to do. They don't get anything done. And then when they do write a law, they write a law like the one that Carter dealt with that says no sanctions on business except for licensing, which creates the odd situation is you can't sanction the business, but you can put it out of business. Now, who would write a sentence like that? But that's what they did. Anyway, if there are no further questions, I think we should stop right there. Anybody?
Well, I want to thank the second panel as well. I mean, I think we can sum up by saying, you know, what a bunch of predictions, right? We're going to have chaos in the states, whether you're pro-enforcement or you're pro getting to more than enforcement. The prediction is chaos in the states to get us to press Congress to do something which they might or might not do. Peter Spiro's really kind of alarming
bank, huh?
prediction. So thank you so much to two fantastic set of panelists. Thank you all for being here.